Welcome to the event Armed Conflicts in Outer Space, the interplay between special regimes. My name is Sima Mordinasab, PhD in Public International Law, specializing in space law. This is officially the first lecture launched by Space Law and Policy Research Project, a multidisciplinary approach to armed conflicts in outer space, called by Daniel Deshane and myself. So why this topic? You know that peaceful uses of outer space is one of the fundamental principles reflected in Article 4 of the Outer Space Treaty OST. However, the risk of the so-called armed conflicts in outer space has become an important challenge in recent years, especially due to the expanding military uses of space applications. This raises several questions, but one of the main ones is what does the law say about armed conflicts in outer space? On the one side, international space law governs and regulates all space activities. The Article 3 of the Outer Space Treaty reaffirms this. On the other side, armed conflicts are governed by a set of regulations known as International Humanitarian Law, IHL, or USIMBEL law. These two branches of international law enjoy unique and special features, pushing them to be regarded as special regimes or lex specialis. And I intentionally don't use the term self-contained regime. That said, we should explore how these two regimes, these two sets of norms, interact with each other in conflict scenarios in a space domain. Joining me today, Christopher Daniel Johnson, Director of Legal Affairs and Space Law at Secure World Foundation, and an adjunct professor of law at the Georgetown University Law Center. Mr. Johnson is also a field editor at the Journal of Space Safety Engineering, on the board of editors of the Journal of Air and Space Law, and serves on the U.S. Board of Directors of a Space Generation Advisory Council, SJC. He's also an external PhD candidate at Leiden University's International Institute of Air and Space Law, writing a monograph on the International Legal Order for the Moon. Mr. Johnson has written widely on space law and policy issues and represents Secure World Foundation at the United Nations Committee on Peaceful Uses of Outer Space, UNCOPOS. With that, I would like to invite our distinguished speaker to present on the topic at hand, which promises to enhance our knowledge. Please join me in welcoming Christopher Johnson. Chris, floor is yours.
All right, thank you so much, Seema. And thank you for the introduction and for that recitation of my credentials. One of the credentials that wasn't listed on there was that I was in SGAC. As I mentioned, I'm on the board, but I was in SGAC and the Space Law and Policy Project Group. I helped establish it with who was it? Joida, back in 2011 or 2012, I think it was. So I'm very happy to see that the Space Law and Policy Project Group still exists. Actually, when I started, it was just the Space Law Project Group. And I think it was Lauren Napier that expanded it, Lauren Napier and Thomas Cheney. So I wanted to say that to say I'm happy to return to see folks from SGAC. I went to Space Gen Congress in Prague a number of years ago, and I occasionally pop back in when it's if I can get to the IAC before in time to see it. As mentioned, I also sit on the U.S. Board of Directors for a Space Generation Advisory Council, and I'm on the investment committee. And I know this is being recorded, so I won't disclose any confidential proprietary information, but you do know that we were, SGAC was a recipient of the Bezos Fund for the Future, $1 million, and that was invested a number of years ago, and we're doing good. SGAC is financially sound, and I'm happy to see the investment exist as something that can assist SGAC in its endeavors as a advisory group to United Nations Office for Outer Space Affairs, advisory group to COPOS, Committee on Peaceful Uses of Outer Space, established at Unispace 3 and meant to be fostering the next generation of space professionals with an international presence. SGAC's presence at the United Nations is sophisticated and professional and competent and impressive. And I'm always impressed when SGAC takes the floor at Copless and we sit near them. SGAC, it's alphabetical, SGAC, then SWF, or we're right near Space Gen. So I've been asked to present today on armed conflicts in outer space. Let's see. I'll share my slides here, and they should appear before you. Please confirm that you can see my slides. Good?
Yes, thank you.
Good. Um, and I didn't see the total number of folks that have arrived in the room. Likely many of you are in law school or law school graduates or lawyers. Maybe not all of you. Um, that's fine. I'm not gonna, this is not gonna be a real law school lesson. In fact, you know, space law and international law, on the one hand, doesn't say enough about how armed conflict or how conflict should be regulated. And on the other hand, it says perhaps too much in a way that leads to confusing or paradoxical results. So the headline of what I need to tell you today is that there's no easy answers. You're going to be confused. The literature and the thought on this is difficult to parse through, and if you're in search of clear answers, you're not going to find them from my lecture or from the law as it exists, the lex lata, the law as it is written. That's because we have different sets of laws, and those laws may, and in fact, do exist um, in a way that is duplicative, possibly overlapping, possibly even conflicting. So we know that the international law is found in the International Treaties on Outer Space. That's a link at the bottom. You should have this space law booklet for you to read in any of the official languages of the United Nations. Space lawyers keep this handy and refer to it all the time. Again, Outer Space Treaty, Astronaut Agreement, Liability Convention, Registration Convention, and Moon Agreement. Outer Space Treaty has over 100 states parties to it, 116 states parties at last count, with a number of signatory states. And it looks as though as Uzbekistan and Colombia were the most recent signatories to it. It is the most widely ratified, and then it decreases from there. But we've seen a real uptick in the last couple of years, last decade, with the Astronaut Agreement, Liability Convention, and a real uptick in acceleration in adherence to the 1975 Registration Convention, which I think is a very important space law instrument, that possibly even more important than Astronaut Agreement in terms of its utility. And of course, less ratification for the Moon Agreement, and in fact, a withdrawal from Saudi Arabia, which was effectuated just in the last year or so. So that's not all that we have for space. We have other rules applicable to space activities. I put here cislunar activities, but of course we have the UN Charter. That explicit link exists between Article 3 of the Outer Space Treaty and the rest of international law, specifically the UN Charter. That's important to call out, if only for textual reasons. It's not often that a treaty makes clear its link to the rest of international law. So that's some pretty wise drafting by the drafters of the Outer Space Treaty. Although drafting practices in the 60s were, they've grown since then in what international instruments do. But that link between the regime of space law and the rest of general international law. Of course, very briefly, we also have the ITU, international environmental law, these difficult things to talk about, customary international law, and another subset of international law called general principles. We mention those because they are mentioned in the statute of the International Court of Justice, Article 38. And historically, why are they mentioned? It is because the ICJ statute, as a successor to the Permanent Court of International Justice statute, threw in as many sources and categories of law as it could think of, because they wanted states to avail themselves of international tribunals to settle their disputes, as opposed to conflict. They said, let's list treaties, custom, general principles, writings of the most qualified scholars, And in fact, even ex aequo bono as sources of law that jurists can draw on because we want states to bring their disputes here into court as opposed to settling their disputes on the battlefield. So that's why we have that listing of sources of law in the ICJ statute. And while we have these difficult categories of law, customary international law and general principles of law, I've really become fascinated by general principles of law in the last couple months, last year or so. And how I think of general principles of law, I think of both. There's general principles of law, meaning general principles of legal logic. A state can't say on Tuesday what it denied on Monday. A state can't assert a fact and then later deny that fact or use its own violation of the law in a way that benefits it. These are just general principles of the rule of law that are based on logic. So there's general principles of law. There's general principles of international law, like Pax sunt servanda, a host of things which exist in the relations of states. That idea that a bilateral treaty cannot bind a third state; it's only binding between the treaties, the states that sign it. That's a general principle of international law. So there's general principles of law that are like logic and philosophy. There's general principles of international law, and then there's even general principles of international space law. That I would say there's Article 2, non-appropriation or peaceful uses, freedom of access to space, probably the non-weaponization in Article 4. These are general principles of international space law. This is how I divided up these different little categories of international law. And we have these other sets and rules that we find in other regimes. And I'm only, at this point, only speaking about binding international law, not looking at soft law, etc. So I'll pass over mention of the Artemis Accords. How I think about it is and this is based on how scholars relate it, kind of a network or a landscape of international law. Think of looking down at a map, then exploring a countryside and seeing that you're in the countryside of international law, but there's one area which is space law, one area which is telecommunications law, and further afield, there's diplomatic and consular relations law, World Trade Organization law, international humanitarian law, international human rights law, maritime law, aviation law, cyber law, Antarctic law, law for the deep seabed, law for trading of cultural and heritage rights. All of these things are special sets of international law that fall under this larger category of international law. When we know this, because if we are to interpret, let's say, the Outer Space Treaty, well, we're relying on maybe the Vienna Convention on the Law of Treaties. We're maybe looking for elements of the law in ICJ jurisprudence. And we'd be doing those same steps if we're thinking about aviation law or maritime law, et cetera, et cetera. The tools of understanding space law are found elsewhere in this broader normative environment of international law, including the very concepts of what a treaty is, how a state is bound by a treaty, what it means to sign and ratify a treaty, how a treaty enters into force, how you modify a treaty, what the provisions mean, how to interpret different elements of the treaty. That does not exist as rules in space law. It exists in the rest of international law, VCLT, and customary international law. Additionally, if a dispute arises pursuant to the Outer Space Treaty, it's the method of enforcement, bringing claims, does not exist in space law. It exists under Articles of State Responsibility as an internationally wrongful act. Yes, it is true that under the Liability Convention, there's provisions on the settlement of disputes and bringing claims, but only for the specific scenario of damage. But if you want to bring a claim to say that a state has weaponized space or a state is not regarding your astronauts as envoys of mankind under Article 5 or not showing you due regard, the way to bring a claim or to solve that issue of an internationally wrongful act doesn't exist in space law. It exists as an element that exists in general international relations between states. And for these reasons, what I've just mentioned, dispute resolution mechanism doesn't exist in space law specific to space law, and the elements of space law exist, and ways of thinking of it exist as part of the larger body of international law. For those two reasons, space law is not seen as a special regime of international law, which is closed off, hermetically sealed off from the international law. It is not a special regime of international law, or it is not a self-contained regime. It is called a special regime. And I'll put links at the very end to resources which have informed and shaped my thinking on this, on fragmentation of international law, that some of you will know, some of you will not know. I think to understand this, this body of thought, you have to contend with these very difficult concepts of special regime, self-contained regime, fragmentation, recourse to the Vienna Convention on the Law of Treaties, understanding how international space law is buttressed or augmented by the Vienna Convention on Law Treaties, the UN Charter, Articles on State Responsibility. They form the backdrop to what we're talking about in space law. I'm going to pause there to look at the chat and see if there's any questions where I explained something too quickly or used acronyms or just wasn't clear. I think we have a small enough group that I can pause for that. So hold on. I think there's something in the chat. Oh, okay. No questions yet. Thank you, Seema. All right. And actually, before I move on, I want to pause. And Seema, any reactions as your moderator, or I want to pause to see if everyone in the chat has any reactions or questions for clarification.
Yes, thank you, Chris. I think that's because maybe some of our audiences do not have any knowledge on fragmentation of international law. If you can just a little bit explain more about the fragmentation, it would be great.
Certainly. In a general sense, this idea of fragmentation is seen as a real challenge, a threat to the coherence and applicability of international law. It's essentially that, let's say, under one set of rules, which are valid and applicable, a subject of the law is required to do something, meaning not undertaking that action constitutes a violation of the law. The law compels you to do it. Let's say you're a citizen of a state where voting is mandatory, and if you don't show up to vote, you violated the law. Yet under another equally valid and applicable set of rules makes the performance of that first norm impossible. You can't show up to vote. Maybe you're in prison. Maybe you're in a hospital, or you're somehow incapacitated and it's impossible for you to show up, or you have to work that day or something like that. You cannot adhere to that rule. So there's two sets of rules, and compliance with both of them is impossible. In fact, to break one, to adhere to one is to break the other. The example that we're going to find as we go on deals with causation of damage in space. Right? In space law, all right, yeah, we may as well get to it. In space law, if you cause damage to another state's launched space object, you are now under a duty of liability, meaning you have to pay compensation. Liability in the Outer Space Treaty and Liability Convention doesn't say that you violated space law. It merely is that you are now under a legal duty to pay compensation for the damage that you've caused, the physical damage that you have caused to another state, another subject of international law. Meanwhile, if those are the peacetime rules. But if you have conducted the causation of damage, if you've executed, implemented, caused the damage to another state space object in the course of an armed conflict, it is positively permissible, lawful to cause that damage. And causing damage, destroying permissible objects in the course of an international armed conflict is lawful, provided you adhere to the norms of international humanitarian law: necessity, distinction, proportionality, and elementary considerations of humanity, the four pillars of targeting and of international humanitarian law. So if state A destroys another state's space object and it believes that it's in the course of an international armed conflict, it's under no duty to pay compensation. It says, this is a lawful target. I'm in the course of an international armed conflict, a IAC, international armed conflict. I'm a belligerent. That other state is a belligerent. I can target that space object and destroy it, and no compensation arises. This is war. So long as I've adhered to military necessity, distinction, proportionality, humanity, I have not committed a war crime, and I can, and that activity is meant to cause the cessation of hostilities, the capitulation and surrender of my belligerent opponent, and me concluding that war, causing the enemy belligerent to surrender and end the war. However, maybe the other side is going to say, we're not in an armed conflict. You are under a duty under space law to pay compensation for damages. You've destroyed that space object. And now you're under the duties of liability to pay compensation for the physical damage. This is the clear example of two sets of rules, space law and international humanitarian law, seemingly applicable, depending on who's looking at the scenario, seemingly applicable to the same scenario and providing different legal outcomes for the subjects of the law and for those actors who are undertaking this activity or subject to that activity. So that's what we mean when we talk about potential fragmentation. Other fragmentations exist. I'm going to put a link at the end to all my sources, or I'll show a slide with all my sources. When we look at fragmentation in international law, other examples of fragmentation are in, international environmental law, a duty to preserve the environment, protect the environment, adhere to the polluter pays principle or precautionary principle. And those rules of international environmental law would be asserted by international environmental lawyers and saying that these are the rules that apply. Meanwhile, advocates of trade and those who do World Trade Organization law and development law will say, well, there's a countervailing rules which say that we're allowed to, use these resources, these natural resources. We're allowed to develop economically. We're allowed to engage in trade with our partner countries. These are our sovereign rights. The two regimes could be held in conflict. So the challenge of the obstacle is fragmentation. Now, how can this be resolved? Again, I'll look back at general principles of international law, and in fact, general principles of law. The two rules, Sima, you know them well, lex specialis and lex posteriori. Lex specialis, special law displaces general law. So if you say, well, there may be two rules which are seemingly applicable to resolve this dispute, but one is more special. Space law is the special law. It resolves this dispute, the space lawyers might say. Whereas the military lawyers might say, no, that's not the special rule. IHL contains the special rule, and therefore it's the one that displaces that more general rule, the lex specialis, general principle of law. And when you read the literature, this sounds like this general principle resolves disputes, this lex specialis rule, but scholars point out, anytime there's a dispute between any special regime, everybody thinks that their rule is the special rule. So the World Trade Organization lawyers say, well, WTO law is more special than environmental law. And the environmentalists will say, no, 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 environmental law is the more special law. So we have that as a general principle to resolve disputes, but everyone asserts that their rule is more special. Sometimes we see the assertion of that lex posteriori rule, meaning the later law displaces the earlier law. To say, well, this treaty provision was entered into by the parties most recently, and therefore it supplants and replaces this previous rule. I guess that might be easier to solve than easier to resolve and to assert. The later rule is easier to find than to say that your rule is more special. I don't know what you do if the later rule is more general than the special rule, which is earlier, because then you have two general principles that are headbutting each other. And how do you resolve when two general principles resolve? Again, I point this out just to say that we're in this realm of philosophy here when it comes to how to resolve disputes in international law, and all of this trickles down to armed conflict in space and how we use the rules of law and the logic and philosophy of law to hopefully come to provide outcomes. So I've spoken about the general rule and the lex specialis rule, the lex posteriori rule, the idea of special regimes, the idea of lex specialis, the idea of fragmentation, all to point out that we run into these issues when we talk about armed conflict in space. And I don't have many more slides after that. Let's see here. But when we take a step back, I want to make sure that everyone, this is what I'm thinking about in the last year or so, is the logic of law at the international level falls into just a few categories. You can sit and read the Outer Space Treaty and say, what is this? What is the normative effect of this rule? Does this rule require me to undertake some particular action? Does it make the regulated behavior in one sense lawful and mandatory, meaning I must do this and my behavior is lawful and permissible? Exploration and let's see here. An obligation. Due regard is a positive obligation. Article 9, guided by the spirit of the principle of cooperation and mutual assistance. Registration of space objects, treatment of astronauts as envoys of mankind, rendering all possible assistance. All of those actions are made lawful and mandatory. You must do them. Or law can fall into the category on the far right there, a prohibition. You must not do this. The regulated behavior is unlawful and compliance with this rule is mandatory. So Outer Space Treaty, Article 4, weapons of mass destruction in space. It is unlawful to place weapons of mass destruction in outer space or station them on other celestial bodies. And compliance with that rule is mandatory. So law can also be a prohibition. And in the middle between these two ends on the spectrum of what you're required to do and what you must not do is this area of permissions, freedoms, privileges, meaning the activity being addressed is lawful and it's optional. Article 1, exploration and use of outer space as the province of all humankind. If you sign the Outer Space Treaty, you're not obligated to explore space. It's not mandatory that you explore space, but you're given the freedom to do so, should you so choose. It says that exploration and use of outer space is lawful and it's optional to you. Access to all areas of celestial bodies, everything from human space flight to commercial space activities to exploration of celestial bodies, rovers and landers. They're not obligatory and mandatory. You're given that freedom. So I've been using this framework, and this is called deontic logic. It's the logic of obligations and permissions. To think about international law. And there's not much scholarship on this, but if you want to have just this X-ray for the law, to say, okay, I have this treaty that's, 15 articles long with all these subsections, you can, with a highlighter, say, what does it require me to do? What does it forbid me from doing? What does it give me the option to do? And this gives you a little bit of more depth to think about all these things I was speaking about before, these paradoxes, these special regimes, these conflicts of rules and whatnot. I add this as another layer to think about international law and law in general. And now, and I think this is my second to last slide. Here's some things I've been thinking about lately, and I think we're getting closer to how to think about conflict in outer space. On the one hand, I said that there's these peacetime rules in space law. How should we regard other states, show them due regard, adhere to the spirits of cooperation and mutual assistance, engage in consultations should harmful interference be threatened, regard astronauts as envoys of mankind, etc. And on the other side of the fence is IHL. You're now in a state of international armed conflict. Destroying something is not a war crime so long as it's, the four pillars: necessity, distinction, proportionality, and humanity. Those two fences, this fence that you can either sit on, the peacetime situation or the IHL situation. But what actually happens in the relations between states is things that are not unsettled and in this gray area. Where, let's say, state A does something in an area outside its territory that it believes is lawful and permissible. And state B, or maybe a host of states B, C, D, E, and F, see state A's actions as unfriendly. And maybe some of them believe it's unlawful. Maybe some of them believe it's lawful. It doesn't seem certain whether it's lawful or not. Now, if they think it's unlawful, they may think, all right, let's bring a claim before the International Court of Justice or the Permanent Court of Arbitration. Let's bring a claim. Well, let's raise this issue at the United Nations. Let's take this to the Security Council and ask for collective security actions and a resolution. But if they don't want to do that, or if they think that that would take too long, there exists in international law and international relations these long-standing principles of countermeasures. And I've become more and more interested in thinking and learning about countermeasures. Meaning, state A does something you don't like. State B, behind closed doors, says, okay, we think that this is a violation of their international obligations, of state A's international obligations. But we don't think the rest of the world is going to agree. We don't think they're going to go, we don't think they would show up at the International Court of Justice. What can we do? What's on the table? What's optional for us? They're going to look into this realm of international law that deals with countermeasures, circumstances precluding wrongfulness. This is mentioned in the articles on state responsibility. State B, it is lawful for state B to respond in a way that maybe isn't lawful a week before this, state A's actions took place. They may, in fact, no longer be bound by the treaty that they thought they were bound by because state A violated it. This treaty may be in breach. States can lawfully take countermeasures against violating states subject to a few qualifications, a few conditions, provided their countermeasures are reversible, non-forceful, and allow the violating state, or in fact, impel or induce the violating state to come back into compliance with the treaty. Countermeasures, I've seen examples in air services agreements where state A and state B agree that they can land their planes on the other state's territory and pick up passengers. And they're allowed to fly in jumbo jets into the other state's territory, but only, 5 a day or something like that. And one state starts flying in things that, they're not fighter, or they're not jumbo jets, or they're too many jets flying in. So the state that seems to see the other state as violating the treaty takes particular measures to bring that other state back into compliance, maybe by denying entry to those that the offending state. Everything is reversible, everything is peaceful, or maybe they don't let the passengers off, or they don't let passengers on when they land, or something like that. They respond in a way that is a little bit escalatory, but isn't a use of force. So I've been reading more and more about these circumstances precluding wrongfulness. It is mentioned numerous times, and countermeasures mentioned in the articles on state responsibility, and it is actually what's going to happen in international relations between states. States won't often go to the ICJ. They won't often trigger the right of self-defense and say, this is an armed conflict, this is use of force, we have the right of self-defense. That's not going to happen. What states actually will do is they will take countermeasures. And the literature on discussing countermeasures, I think, is a bit shallow, especially for space activities. So I'm learning more about this, and I think that having a deeper knowledge on countermeasures is what we can do as counsels to states, and to think about how states respond to unfriendly but illegal, or maybe unfriendly but not clearly illegal, activities of other states. I'll leave it at that, but merely to show that when we think about military uses of outer space, there is this spectrum. At the far end of the spectrum, there is armed attack, which allows for self-defense. But everything short of an armed attack certainly allows for consultations with that state that has, which you feel is in violation or acting aggressively. Certainly retortions, which we sometimes call countermeasures, and then non-forcible countermeasures. So as we exist in this, as states exist in certain circumstances in which aren't clearly use of force, which aren't clearly armed conflict, what is actually going to happen is countermeasures. And space lawyers have not traditionally looked at countermeasures because space lawyers are thinking only about the Outer Space Treaty. They're not thinking about the rest of international law and the principles which exist that have built up over the centuries for countermeasures and self-help in other domains, which can serve to, I would say, de-escalate or not escalate what could spiral out of control and cross over into an international armed conflict. I think, yeah, that is my last slide, besides references that this is a host of very wonderfully challenging and intelligent literature that I have enjoyed reading over the last half decade on fragmentation, self-contained regimes, Marty Koskanini's Fragmentation of International Law, his report to the International Law Commission, that second to last source right there. If you are inspired or confused by what we've been speaking about, this is a deep dive into these issues that we've been thinking about on fragmentation, approaches to fragmentation, the notion that fragmentation is inevitable. It is not a flaw in international law. There is general principles that what states sign and enter into force in their treaty obligations is not meant to be paradoxical or contradictory. It is meant to be read in a way that is that doesn't cause fragmentations and normative conflict. And that the way that there are certain pathways out in terms of what he talks about, this systemic integration, meaning reading treaty articles, not in exclusion, but in a holistic manner of interpretation and application. So I really enjoyed reading all of these deep thinkers on international law over the past half decade or so. And if what I've been speaking about is interesting to you, um, if what I've been speaking about is interesting to you in the context of armed conflict or just international law theory in general, then I definitely encourage you to find these things. And I'll, after I stop sharing, I'll post a link to these slides.
Okay, so thank you so much, Chris, for your very interesting and informative lecture. And we have several questions in chat box. I've also have some questions for you.
Okay.
But before that, I would like to first add Chris' article on self-contained regime because he didn't mention in the references. He has also an article in 50 Years of a Space Law about this question that whether space law can be regarded as self-contained regime or not, because I saw that some of our audiences ask this as well. And what I realized from your presentation is that so there is a wide range of rules and regimes that are applicable to armed conflicts in outer space, and each of them comprise of obligations, prohibitions,
Mhm.
and what was the third one?
Let's see. Obligations, prohibitions, and permissions or liberties, right
Okay,
in the middle.
yes, perfect. And I would also like to highlight what Chris said about countermeasures, that resorting to countermeasures should be non-forcible. So states can resort to countermeasures whenever that the countermeasures would be peaceful for them. And it is very interesting to also refer to the ICJ advisory opinion on nuclear weapons when the ICJ deals with the relation and interaction between two special regimes, that is IHL and human rights law,
Mhm.
and it deals with how which of these regimes can be applicable to armed conflicts in outer space. So our audience can also see this advisory opinion as well. And now I would like to go through the questions, if you agree, Chris.
Sure.
Okay, perfect. So I will start with my questions. You talked about general principles of law, and what I would like to ask you is that because I think that the law on armed conflicts in outer space is one of the emerging law or regimes in a space law. And I would like to know that do you think that general principles on a space law or maybe general principles of international law can address any legal gaps or lacuna that we have during armed conflicts in outer space?
They must be able to. We have to use them. I think, you know, as I was reading more on general principles, it's, you know, this is where I become really uh not disillusioned, but really just I like hopefully wiser about international law. It's like if the law gives you an outcome that you don't like, or you're arguing a moot court, or you're asked to get to a conclusion and you don't like what the law seems to do, go look for some general principles to come to a different conclusion.
Mhm.
Like lawyers can usually find, they should be always be able to find something to rebut a conclusion. You know, there's a legal response almost to everything. So to every side, especially in space where we have just general treaty provisions that are vague yet binding. Like space law is a brief regime, and its normative deepness or thickness it isn't there like United Nations Convention on the Law of the Sea, which is 300 articles long, or international aviation law with its ICAO convention and numerous standards and recommended practices, or ITU Constitution and Convention, which is like thousands and thousands of pages. We're dealing with the space law. We're dealing with very generalized principles. And so we can, I don't know, I think often we can do a lot of, there's a lot of wiggle room, I think. Does that answer your question?
Yes,
Yeah.
yes, perfectly. So the second question is that, so do you think that is there any fragmentation in regulating armed conflicts in outer space? I mean that, do you think that IHL norms um, conflict with rules of a space law during conflict? Because about lex specialis and lex posterior. So, do you think that we should resort to these conflict resolution principles to resolve any conflict between IHL rules and space law rules during conflict scenarios in a space domain or not?
Um, Let me think here. Space law
Okay.
applies during peacetime. And when we cross over to a armed conflict, we have to cross over to IHL rules. So in principle, there shouldn't be any actual conflict between space law and IHL. Um, and this was understood during the drafting and negotiation of the Outer Space Treaty. But there's lots of, I would say there's lots of gaps and lacuna that exist in space law. And we're slowly trying to solve them, whether it's, the gap that exists in Article 4 with weapons of mass destruction. But you have to understand Article 4 in that historical context of the 1963 Partial Test Ban Treaty, no testing of nuclear weapons in space. 1967 Outer Space Treaty, no WMDs in outer space. 1970 NPT, Non-Proliferation Treaty, and then whenever the NMOD convention was, I think there was also the 60s, the NMOD convention on the prohibition on environmental modification techniques in the courses of armed conflict, including in the space domain. Article 4 exists as a security and arms control provision in the context of these other arms control provisions. And we're still working on um, normative advances at the United Nations under the open-ended working group on responsible behaviors in space, which is meeting, I think it's a couple weeks in Geneva. If you can define responsible behavior, then you're in so doing, you're defining irresponsible behavior. Likely that won't lead to a binding treaty yet, but give it a decade. We'll see where we get.
Okay, thank you. Excellent. So we have a question that somebody asked, over the years, we have observed superpowers violating international laws without facing consequences. Why would the space laws be any different?
So I think how states, so actually, and this is an answer to fragmentation. Um, Regimes are not, international law is not fragmented because there's a set number of states that exist in the world and they have to have continual relations with them. So, we don't have that prisoner's dilemma. The prisoner's dilemma is only played once in the scenario of the prisoner's dilemma. What we have in actual international relations is if state A does something which state B doesn't like, they don't have to necessarily respond in that domain using that set of rules that they believe has been violated. There's a host of other domains and future scenarios where they can respond. So if a state A says something that seems to be a threat of force or something against, let's say, the territorial integrity or political independence of another state, well, state B, which feels as though it's been offended, may just pull state A's products from its shelves and stop going. And the tourists from state B may stop going to state A, and loss of most favored nation trading status, consequences in terms of trade, consequences down the road when state A wants state B to be in a coalition for it. So what happened let's say on Monday, state A does something which state B doesn't like. It's not as though State A is going to be hailed before the ICJ the next day. But now the relations between those states has eroded. State A may be seen as a untrustworthy partner in international relations. There's reputational consequences, et cetera, et cetera. States exist in continual relation with other states and in a whole network and community of other states. And long-term rationality, which is what we should have, uh, requires that states take into that account their reputational and long-term interests and values.
Yeah, thank you. So because we are out of time, I would like to just
Too long of an answer, sorry.
yes. No, 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 no. We have several questions, so
Oh, okay.
I would like to just pick maybe two of them, and then I think we should end the event. So there is a very interesting question here, and Anna said that how does one define armed conflict in space, considering there are many dual-use technologies that exist? And how does the notion of attribution fit into this discussion about legal regimes?
Let me read this question. Which question? What question is it?
Anna
Who?
Fagnan.
Oh, it's the
If I,
dual use one. How do we define armed conflict in space?
yes,
That one?
exactly.
How does one define armed conflict in space? Hmm. Well, I think there's a definition of aggression, and I think armed conflict requires, look up the definition of armed conflict. It's two belligerent sovereign states. There's international armed conflict at IAC, and then there's non-international armed conflict. There's elements of international armed conflict, um, as we would define it anywhere else.
Yes.
And so not specific to the space domain, I'd say. Yeah, general understanding of armed conflict, I'd say.
Yeah, exactly. The definition that we have in international humanitarian law and also some cases in ICTY and
Mm.
Geneva Conventions,
Mm.
as Chris mentioned. So I think if I'm not wrong, the armed conflicts was defined in Tadic case in ICTY.
Okay.
So
Okay.
I think she can take a look at it. And maybe my last question for you. Um, so Dan said that, then asked this question that given that major powers have continued anti-satellite testing despite existing international space law obligations, what evidence do you see that new norms or legal frameworks would be more effective at constraining destructive space activities?
Yeah. So if a state blows up its own space object, is are the provisions of damage invoked? They're not, because they've destroyed their own space object. So there isn't damage caused to another state space object. They've destroyed their own thing. The only thing we can point to, and that's why states have done those anti-satellite tests to destroy their own space objects, because it's not an act of aggression, a use of force. They're blowing up their own object. Um, the only thing we can point to is the ideas on harmful contamination, both from international environmental law, transboundary harm, Corfu Channel, etc., and Article 9, due regard, harmful contamination. But it's not clear. You may say, oh, it was contamination, but it's not harmful contamination. Or you may, and when states have done those ASAT tests, there's been ripples and rumor and murmurs at the UN, but no state actually accused another state of violating international law. This is why I talk about countermeasures. Um, but yeah, we definitely do need stronger rules for that. And we're slowly getting there, as I mentioned, that OEWG on
Yeah,
responsible behaviors, and who knows where we'll get to at COPUS.
yeah, that's great. Okay, we have still many questions in the chat, but I don't know if they can reach out to you or ask their question maybe later, or maybe I can put my email address here if they want to reach out to me, and I will try to reach out to Chris and
Okay,
have some
yeah.
answers.
Yeah, and
Yeah.
I did I put my no, my slides don't have I'll put my email address on the title slide.
Okay, so I will write mine here, Chris.
All right, there we go.
Okay, so with that, uh, I would like to thank Chris for joining us today. It was very, very, very interesting presentation and lecture, and I'm sure that it is very useful and helpful for our research project within Space Land Policy Project Group. And I hope that has been very helpful for our audience. I'm sure that it was because many questions for you. And thank you everyone for joining us. I would also like to thank the core leadership of Spaceland Policy Project Group for their constant support. So I think that we should,
And
yes,
one more thing,
yeah.
everyone who is in SGAC, stay involved with SGAC, and I hope that you can use the SGAC network to get involved in space activities, including space law, and maybe, get on the SGAC delegation and attend COPUOS or other UN fora that are very important and really gonna, introduce you to the space law arena. You can work in this field, and we need space lawyers. That's all.
Okay, perfect. And somebody said that Chris, thanks Chris for waking up at 4:30 a.m. for the lecture.
Wow.
Okay, so thank you so much, Chris. And thank you, everyone. I think that with that, we should end the event. Thank you.